4CRB now presents Legal Matters, proudly brought to you by Bell and Senior Lawyers. Call them today for all your legal needs on 07 55 32 8777. This program provides general legal information only. It's not personal legal advice. Everyone's situation is different, so please seek independent advice for your own circumstances.
And as the promo says, it is a very good morning to Andrew Bell, and I'm going to emphasise this, our brand new sponsor of the program from Bell and Senior Lawyers, not to be confused with the old sponsor. Good morning to you.
Good morning, Colin. Great day outside. Lovely to be here.
It is. It's nice to see winter is on its way and we're starting to get that stable atmosphere, cooler temperatures. Just nice.
So today we're continuing our look into property law on the Gold Coast that we started last week. So I thought I'd just start with a bit of a summary of the takeaways that we discussed last week and remind people to call into the show.
Yeah, absolutely. And that number, do not leave it to the end of the show. 0755 208888 is the number. It is a talkback program. As much as I know you love the information, we'd love to hear from you. 0755 208888.
So, Colin, last week we discussed that in Queensland there's a new disclosure regime that started in August last year, and this requires preparing what's called a disclosure statement, or a Form 2, as they call it in the industry, and that has to be done before you list a property or before you have an auction on the property. And you can't do it after the buyer has signed a contract, and you can't amend it afterwards. And the reason why we're mentioning that last week and this week is because it's causing a lot of confusion to people, and it has great problems if it's not done properly. So the disclosure statement, if it's defective in any way, means that the purchaser of the property can cancel at any point up to and including settlement with no penalty to them. So that Form 2 must be prepared properly and correctly. And then the other confusion we have is people now think that there's disclosure of everything, but the Form 2 covers administrative type things, like is there a court action, is someone planning on repossessing or building a road through the property, but it doesn't discuss things like building defects or flooding history, so you make sure you've still got searches you've got to do afterwards. So if you're a seller, make sure you do it properly, and if you're a buyer, you've got to review it really carefully and make sure that the legal and title matters that are disclosed are correct and that you're happy with them, but then also consider your options under a cooling off period, or noting that you can walk away if you do subsequently find a problem with that disclosure.
Now, we did do the first half of this program last week, so if you missed out on it, you can review that online and download the program, or just listen to the program online on either the Bell and Senior website, or you can do that also on the 4crb.com website. Now, we're going to be talking about buying off the plan today, but it is a talkback program. Do not leave your question to the end of the program. We'd love to hear from you. 0755 208888 is the number. Now, Andrew, we did get a question via email last week. It was very long and elongated. Did you want to tackle that one first?
Absolutely. Let's start with that, Colin.
Now, I'm summarising about 4 to 6 pages, but basically it boiled down to Robin was considering buying a property at auction, and the Form 2 was delivered. There's an illusion of QCAT matters, potentially with either a fence or a tree or trees on the property. There wasn't a lot of detail, and when asked, could we get some more detail on that, there was privacy was stated, and so she door knocked the suburb of the neighbours around the property, and no one knows anything about anything other than a historical memory of two people, the previous owner of the property and the previous owner of the adjoining property, having some tree disputes, but they are now no longer there. So it's an interesting one.
It is. So I think this raises a few issues, Colin. We talked about QCAT a couple of weeks ago, and if we go back to that, if you start a QCAT matter, you then need to serve your documents on the other side. Once you've done that, the matter is open. And they're typically open until either the problem goes away, someone cancels it, or there's a final decision in the matter. So potentially there was a final decision in the matter and it wasn't logged or made available, in which case there would be no liabilities. However, if they are at QCAT, the majority of QCAT decisions that are likely to be relevant to an incoming property owner are going to relate to a retaining wall, a fence, or a tree. So if you're doing a building and pest, I'd advise you to look at those things and see if they're in disrepair, see if there's see what the cost would be to rectify it, and that's probably the maximum risk that you're going to have under QCAT. Because QCAT's going to either order, if there is a problem, that you either contribute partially or completely to fixing the fence, the tree, or the retaining wall. So those people being on notice can at least work out what the potential value of any claim would be. However, it is likely that this would have expired out over time.
Perfect. Well, it was a long-winded question. Hopefully that has pointed you in the right direction, Robin. And you can email your questions in. They will be asked and answered the following week. mail@4crb.com. Don't forget to call in. We'd love to hear from you. 0755 20 8888. All right, we're going to start buying off the plan. And let's turn to off-the-plan purchasing, which is enormous on the Gold Coast. Why is it so popular here?
Well, I think it's popular here because a lot of people, normally if they're buying a house to live in, aren't buying something off the plan and waiting a couple of years. We have the aspirational lifestyle here. We have plenty of development of building high-rise apartments. And then there's also the financial gain side of things. So when you combine all of those together, the Gold Coast is one of the most attractive off-the-plan markets in Australia. And for those who don't know what purchasing off the plan means, it means that a developer has the intent to build either a housing development with houses or with townhouses or a unit or a multi-storey complex. And then you purchase into by paying a deposit up front, sign the contract, and in a couple of years you become liable to pay the rest of the amount. Now, the benefit that you have as the buyer is you may get to buy into something that doesn't come up for sale frequently. You might be very excited about the location, like the new mega tower they're building in Southport. I know that was incredibly popular. I know an agent who sold 14 off the plan in a week.
Sure.
Or it may be the cost appreciation. So there have been many examples where people have financially done very well. They've even sold their interest in the property before they've even moved in and made a profit off it. So small deposit, potentially even buying it with your super, and then you can end up with a luxury new place at the end of a couple of years.
Nice. But what are the genuine legal risks that buyers need to understand?
So because you have all this money tied up, you're putting a lot of faith in the developer for a long period of time. So there are examples, for example, in Coolangatta, where a two-bedroom apartment was sold off the plan for $900,000 and was resold before completion for $1.7 million. So they made nearly $800,000 or a massive return on their 10% deposit before they'd even moved in. And that's why people are attracted to these things. But the legal risks relate to a number of factors. There's valuations, sunset clauses, and developer insolvency, and variations of what gets built. So we can go through all of those, but I remind you to call in.
And we'd love to hear from you, 0755 20 8888 if you've got a question. Doesn't have to be property related today, but we'd like to hear some property questions if you do have them. 0755 20 8888. All right. Well, there's lots to consider there. What protections do buyers now have around sunset clauses?
Okay, so a sunset clause is a provision in the contract that allows one or more parties to terminate if the project doesn't complete by a certain date. So you may say, well, I've got $100,000 or $200,000 locked up. The developer's late. I want my money back. But normally it works in the opposite direction. People want their house delivered and the developer won't necessarily deliver it. And the contracts often have abilities to say, well, if this goes for more than 3 years, then the developer can can cancel the contract. So in a rising market, unscrupulous developers have been known to deliberately delay construction past the sunset date, terminate the contracts, return everyone's money, and then resell the same apartments that people had been waiting for 3 years to live in or sell to new buyers at a significantly higher price, and effectively lock in the price gain that you were expecting as an investor. So in November 23, Queensland amended the property legislation, and under the new framework, a developer can only end a land contract if the buyer gives written consent to do so, or if there's an order made by the Supreme Court. So it's more beneficial for the investor than it would have otherwise been. However, the limitation only primarily relates to contracts for the sale of land. Strata title, so apartments, townhouses, and some units under community title schemes remain subject to some of the same risks. The Queensland government's looking at considering changing that, but note that if you're buying a house, then you're protected, and if you're buying an apartment, you may not be.
Okay, so that is very interesting. We've all heard some of the stories around these sunset clauses. They've been famously handled by A Current Affair and 60 Minutes, but it sounds like there are starting to discuss protections. And it seems desperately unfair when you've lent the money or put a deposit together, and so have multiple other people, and the developers have used that money to finance the building in the first place. So everybody should win, including the bank that's probably lending the money along the way. And unfortunately, it seems like the developers have the ability to get out of jail free.
I agree, and it's particularly difficult to force them to do anything. And if you don't, then you run the risk of the developer going insolvent. You can't expect them to keep going if they're losing money as well, so it's tricky. And if they do go insolvent, one of the problems is, you're talking about the banks. The banks normally have what's called the primary mortgage over the title. And if anything happens, they typically have enough reserve that they can sell the land and recoup their money. But if you've put down a deposit, you may lose it if the developer goes insolvent. So
there are risks against the rewards that you are potentially looking at, right?
There are, and understanding those risks is a really important factor about going off the plan. And we often see that these contracts can go to 700-800 pages nowadays, which is incredible.
Wow.
For a contract for people to expect to understand. And I get asked the question, well, aren't they all standard? And the problem is, no, they're not all standard. They're often written by one lawyer who's selling 100 units in the high rise, and it's a bespoke contract for that particular development. So everyone buying in really should read and understand the risks that they're getting themselves into.
All 800 pages. And so you can see how some of the bills along the way can get expensive.
They can. And then there's all sorts of other things that can come up as a result of those. For example, in many contracts, the developer can actually ask you to add an additional contribution. So we call that specification variation, but they may either say that we need more expensive materials and you need to pay for that, or alternatively, they may say, well, if you don't pay for that, we're going to really cheap out on the materials you get. So what you end up getting delivered isn't what you thought you were putting the deposit down for originally.
Wow. So there's a lot of concerns and worries. This is a Talkback program. We'd love to hear from you this morning. Now, we're halfway through the program. Do not leave your call any later than this. 0755 20 8888 is the number. What should a solicitor check in an off-the-plan contract before you sign?
Okay, well, the issues that we were just talking about, for example, the sunset date. Is it realistic for this kind of development? Is it 12 months on something where the marketing materials or the place next door took 3 years to develop? If it's only 6 months away in a 200-unit tower, it's probably unlikely, and they may just be using your money as an interim financing measure. Whether the sunset clause operates in their interest only. Again, if you're in a falling market, you may want to offload your development. So if you have been waiting for 3 years and it's worth less than you thought it was going to be and you've got other opportunities, can you pull out? How do you pull out? There's different ways that deposits are structured. I've seen lately contracts come through where it's not a true deposit. It's structured as a loan to the developer, an unsecured loan.
Wow.
I'm seeing things where people are coming through with some sort of lay-by where you can put down as little as 2% on the value of the apartment. So what is the deposit mechanism? How is it protected? What visibility do you have over it? Can you put in a bond rather than cash, or do you have to tie up all your assets? So there's a financial aspect, there's a legal risk aspect. We also look at things like the variations clauses. So again, if they do want to vary the contract, say you thought you're buying into level 50 and they only get enough interest to build it at the level 20, and you're not even getting a penthouse at that price, you're going to be on the ground floor, you're probably not going to be very happy. So if they do vary it, can you pull out? Can you get a refund? What are the mechanisms in place if there's a change? If the developer asks for more cash, what time do you have to provide it? I've seen them as little as 15 days where the developer can say, I need an extra $100,000 or I'm cancelling your contract. And
Wow.
people have 15 days to get the money. Well, are you in a position to raise significant cash at a very short period? Because if you're not, you might want to look into other protections or buying into another development.
Yeah, okay. So there's lots to consider, and I suppose that's why they're 800 pages long and do require a fair amount of consideration, especially when we have heard about those sunset clauses. Now, did we adequately cover that one off, Andrew? We're going to be moving into a different block in a moment.
I think so. The only other one really is what we call the valuation gaps. So when you purchase the off-the-plan contract today, you're paying a price that will be settled in 1, 2 or 3 years. The bank doesn't value the property at the price you signed today. They'll value it at the date of settlement based on the market at the time. So if the market weakens and the bank value changes and values it below your contract price, then you might be forced to fund the entire shortfall from your own resources at settlement. So you've also got to be careful that you either need an option to renegotiate the price, or you've spoken to your financial advisor to make sure that if there are any changes, that you're able to actually cover them. Because if you're short the money, then you may actually forfeit your deposit on the date of settlement.
All right, this is a Talkback program. If you'd like some free legal advice, the time to call is right now, 0755 208888. And we've got our first caller. Very good morning to Cheryl. Cheryl, ask your question of Andrew.
Good morning, Andrew. Thank you for taking my call. This has got to do nothing to do with property. It's
That's
to
all
do
good.
with end of life situation. So I realise that at death, the enduring power of attorney is nullified. Now, I'm just wondering, what is the smoothest and easiest way for my executors in my will to go on then to be able to operate on my bank account, to pay ongoing expenses or to pay expenses and to sell my property?
Well, first of all, if you are concerned about that transition period, are your executors the same people who have your enduring power of attorney?
Yes.
Okay, so effectively they would just need to turn up to your financial institutions with a copy of the death certificate and a copy of the will. If probate's required, then they would need the certificate from the Supreme Court as well. But if they already have the access to those accounts because they're power of attorney and they're continuing on as executor, as long as the will has powers for the executor to make financial payments and continue your estate in the interim before funds are distributed, then that should be sufficient to be able to protect you. So the wills traditionally were seen as locked down. People even had problems paying for funerals, etc. However, it is possible in the will to direct your executor to maintain your properties, pay for a funeral, maintain investments, etc. as part of the powers you give the executor before money is distributed among to the beneficiaries, as long as you've catered for that in the will.
Right. Okay, so I need to make sure the will is watertight on those issues.
Yes, that would be my recommendation.
And is there any way in Queensland of not having to go through probate?
It normally depends on the financial amount that the estate is for. Typically, if someone's sole owns a property, you're above the threshold and probate would be required. However, very small estates don't typically go through probate.
So what is the threshold, please?
I will have to look it up and get back to you. I think it's $100,000, but I am...
Oh, right. Okay.
I'm not 100% off the top of my head.
Okay. Thank you very much. Thanks for that information.
Thank you, Cheryl.
Okay, bye.
All right. If you'd like to ask a question just like Cheryl has, 0755 208888 is the number. We're in the final 5 minutes of the program. Some free legal advice would be helpful. If that's the case, give us a call, 0755 208888. We might just go to a message from our sponsor.
Wills, probate, powers of attorney or property matters. Legal issues don't need to feel overwhelming. Call our trusted sponsors, Bell and Senior Lawyers. They explain everything in plain English and guide you through every step of the way. For caring, experienced advice, phone 07 55 32 31 33 or head to bellsenior.com.au today. Bell and Senior Lawyers, making legal matters simple.
All right, we're back. 0755 208888 is the number if you'd like to ask a legal question of Andrew Bell from Bell and Senior Lawyers, our brand new sponsor of the program, Legal Matters. All right, we are talking property law, and let's have a quick question heading back to what we were talking about last week. When do you need that solicitor involved with the process?
Okay, so in Queensland, while there are people who are conveyancers, everyone who's actually transferring title is a solicitor or working for a solicitor's firm. In New South Wales, there are licensed conveyancers who act independently. So if you're buying or selling, you do need to engage a law firm. Now, whether you engage a law firm that's run where you're dealing with a solicitor, you're probably going to be paying more. If you're paying with a conveyancer who reports to a solicitor, you're probably going to be paying less. So when you should pay for a solicitor versus when you should go with a conveyancer, to me, all determines on your personal situation and the complexities of the transaction. If it's a very normal block being sold with no issues on title, one person transferring to another entity with plenty of time, with no financing issues, no simultaneous settlements, no other bits and pieces that could go wrong, I'd steer you towards a conveyancer and save some money. If you're conveyancing things from a mortgagee's sale to a family trust and there's other finances involved, or like earlier, there may be legal action on the matter, on the property, or there's very tight time frames, or you're looking at buying and reselling, then the more complex the matter, the more I'd suggest that you speak with a solicitor instead of a conveyancer.
Look, very solid advice and common sense in most cases. Again, it's a lot of money, isn't it, when you're buying property, and it's better to be safe than sorry.
Absolutely. It's normally the most expensive thing that people do, and paying a few $1,000s more on what's a median house price of over $1 million now to make sure that it's done properly is, I think, definitely worth that level of insurance.
Final 3 minutes of the program. 0755 208888 is the question. We could fit one more of a question in from you if you call right now. So we might launch into the summary, Andrew, of our discussions over the last week and this week.
Okay, because we will be doing another topic next week. So I'll wrap up property here from some of my notes. So we talked about buying off the plan. I'd strongly recommend that you don't buy off the plan without a solicitor reviewing it first and speaking with your financial advisor. And you understand the risks around valuation, sunset clauses, and variations. A bit that we didn't get to is first homeowners grants. First homeowners grants currently a generous $30,000, which expires at the end of this financial year. They typically renew them, but there's no guarantee, and sometimes that announcement can come months afterwards. So if you're looking at settling a first homeowners grant, do that now. And then back to some of the takeaways from last week. Those Form 2s, make sure that you get onto them and review them before they go out, before you're marketing the property. If you're buying, look at it carefully and remember that you can cancel on that basis. And one other thing that we didn't get to talking to is about cancelling contracts. And be very careful. Again, we're looking at large amounts of money. Deposits are now typically $50,000, $60,000 just to put your name down to purchase a property. So cancelling a contract can have massive consequences. Be very careful if you're a buyer or a seller and contemplating cancelling, looking at what the risks are to you. Speak with your lawyer and your financial advisor, because you may still owe the real estate agent their commission. You may or may not be able to keep a deposit if you're about to cancel a property. So if you are cancelling a financial transaction, be very careful with that, and make sure that if you are purchasing a property, get the insurance done on it straight away in case anything bad happens between signing the contract and settlement.
Yes, very interesting information, Andrew. Thank you very much for your time. I'd like to also thank those callers or caller, Cheryl this morning, and those people who emailed in, Robin. You can email in your questions, mail@4crb.com, and we'd love to hear from you. This is a Talkback program. Andrew will be joining us again from our brand new sponsor, Bell and Senior Lawyers, next Tuesday at 9 a.m. Thank you very much for your time, Andrew.
I'll see you then, Colin.
You've been listening to Legal Matters, proudly brought to you by our trusted sponsor, Bell and Senior Lawyers. Call them today for all your legal needs on 07 55 32 8777. A copy of this and past programs and all relevant resources will be available for you to replay or download on bellsenior.com.au and 4crb.com.